Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. Today in this video, I am going to discuss one more important question relating to the company law. That is about the Memorandum of Association. My question is, define the term Memorandum of Association. Also define its form, contents, as well as purpose of Memorandum of Association. If we talk about the company, Section 3 of the Company Act defines that a company may be formed for the lawful purpose by 7 or more members where the company formed is to be a public company. And in case that is a private company, there may be 2 or more persons. And in case of one person company, there is only one person. By subscribing their name or names to a memorandum of association and in complying with the requirements of the registration also. So we can say that the preparation of the memorandum of association, that is an important task in the formation of the company. It is a document of great importance. As per section 2 clause 56, memorandum means memorandum of association. That is as originally framed or altered from time to time in the pursuance of any of the provisions of the company law or of this act. A memorandum of association is very important document for the company. The memorandum of association sets out the constitution of the company. It is the charter of the company upon which the foundation of the company is based. It defines the relation of the company with the outside world and the scope of its activity. It contains the fundamental conditions upon which alone the company is allowed to be incorporated. Every person dealing with the company is presumed to have identified the provisions of the company law, and any act done outside the power given by memorandum of association, that is ultra vires and cannot be ratified even by whole body of the shareholders. If we talk about the purpose of the memorandum of association, the purpose of the memorandum of association is to enable the shareholders, creditors, and any other persons dealing with the company to know what is permitted range of the company or the enterprise. According to Palmer, the Memorandum of Association contains the object for which the company is formed, and therefore it identifies the possible scope of the operations beyond which the operations of the company can't go. And it defines the power of the company, and act done beyond these powers will be ultra vires of the company, and therefore it will be void. If we talk about the Memorandum of Association, that is a public document, and everyone dealing with the company is presumed to know the contents of the Memorandum of Association. As per Section 17 of the Company Act, a company shall be requested, or a company shall on request of its member send him within 7 days of the request and subject to payment of the prescribed fee a copy of Memorandum of Association as well as Article of Association. In case of any default in complying with the provisions of this section, the company and the defaulting officers shall be liable. If we talk about the form of the Memorandum of Association, that is defined under Section 4 Clause 6 of the Company Act. The Memorandum of the company shall be in respective form specified in the table A, B, C, D and E of the schedules as may be applicable to such companies. These are as follows. The form in the table A, that is applicable in the case of companies limited by shares. If we talk about the form that is in table B, that is applicable to the companies limited by guarantee, that is not having a share capital. Third one is table C is applicable to the companies that is limited by guarantee having the share capital. And table D is applicable to unlimited companies having a share capital. And table E is applicable to unlimited companies having the share capital. And the Memorandum of Association shall be printed and must be divided into paragraph, that is numbered consequently. And it must be signed by each of the subscribers with their addresses, description and occupation. If we talk about the contents of the Memorandum of Association, as per Section 4 Clause 1, the Memorandum of the company, that is limited company, the Memorandum of a limited company contains the certain clauses. That is name clause, registered office clause, object clause, liability clause, capital clause, association or the subscription clause, and the nomination clause in case of one person company. Now I will discuss with these one by one. If we talk about the name clause, being a legal person, a company is recognized by its own name and is having a separate legal entity. The memorandum of the public company limited by The memorandum of a public limited company must state its name with the limited or the private limited company as its last word in the case of private limited company. The memorandum of a public company must state its name as a limited and the private company must state its name as a private limited company. A company is free to adopt any name it likes, but it should not be identical with the other company that resembles with the nearly to the name that is existing company. Second one is name shall not such that its use by the company will constitute an offense that is under any law for the time being in force. Third one is name shall not undesirable in opinion of the central government, and the name should not be misleading. So a name is undesirable if it is identified with or closely resembles to the name that is existing company. There are the certain leading cases relating to the names of the company. First case is Wing versus Buttercup Margarine Company. In this case, the plaintiff was carrying on the business with the Buttercup Dairy Company. A new company, Buttercup Margarine Company, was incorporated, and the plaintiff sued the new company, restraining it from using the name, as it is likely to deceive the people in thinking that the both companies are related to each other. Court restrained the newly formed company to use the said name and granted injunction. Second case, that is in Society of Motor Manufacturer and Traders Limited versus Motor Manufacturers and Trading Mutual Insurance Company Limited. In this case, the appellant company filed suit against the respondent company for restraining it from using the said name, but was rejected by the court. And it was held by the court that the name of the respondent company was not identical with the appellant company. So, resembles it. And the second clause, that is Register Office Clause. As per Section 12, Memorandum of Association must specify the state in which the registration office of the company is situated. Necessary for affixing the domicile of the company. Second one is, per Section 126, it provides that every company shall prepare and keep its registered office, financial statement along with the books of account and other relevant books and papers for the financial year. So a company must have a registered office within 15 days of the incorporation, to which it is communicated. Notification must be added. A company may have registered office in one state and carry on the business in another state. That was about the registered office clause. And the third clause, that is object clause. As per Section 4 clause 1, it states that the memorandum of the company shall state the object for which the company was incorporated. It is most important clause as it defines the company's purpose and power of the company. About the purpose office clause, its purpose may be threefold. The first one is protection of the investors. Second one is protection of the creditors. And the third one is preventing the acts that may go beyond the MOA. Thus, I will discuss with the purpose one by one. Firstly, that is purpose for the promotion of the investors. It protects the investors who learn from the purpose of the company from the memorandum for which the company was formed, and ensures that their money will not be risked in any of the business which is not authorized by the memorandum. And the second one is protection of the creditors. It protects the creditors also by ensuring that the company's funds are not applied in unauthorized activities. And the third one is act done beyond the power conferred by the memorandum will be ultra vires. A company may choose any of the object for which it has been formed, but that purpose must not be illegal, unlawful, or against the Company Act. Fourth one is serving the public interest. It protects the public interest by preventing the diversification of the company's activities in directions. This was all about the purpose clause. Next clause, that is liability clause. As per Section 4 clause 1, memorandum of the company shall state the liability of the members of the company, whether it is limited company or unlimited liability company. Thus, in case of company limited by shares, it shall state the liability of the members that is limited to the amount unpaid value of the shares. In case of the company limited by guarantee, the amount up to which each member undertakes to contribute. it also state. So the assets of the company in the event of winding up for the payment of the debts and liabilities of the company shall also be stated. And to the cost, charges and expenses of the winding up and the adjustment of the rights of the contributors may also among themselves should also be stated. Next clause, that is capital clause. As per section 4 clause 1, in case of company limited by shares, memorandum shall state the amount of share capital with which the company is registered and the division thereof into the shares of a fixed amount and the number of shares which the subscribers of the memorandum of association agrees to the subscribe, which shall not be less than one share. In case of one person company, the name of the person who is in the event of who in event of death of the subscriber shall become the member of the company. And the next clause, that is association or the subscription clause. Memorandum shall contain a declaration at the end of memorandum that the persons subscribing their signatures to the memorandum are desirous of forming themselves into the association and in persons of the memorandum. Each such subscriber must sign the memorandum of the association in the presence of at least 6 witnesses. This was all about the clauses that is contained in the memorandum. And the next one is alteration of the memorandum. As per section 13, a company may by special resolution and complying provisions and procedure specified in section 13 may alter the provisions of the memorandum. As per section 6, however, a limited company having a share capital may alter the capital clause of the memorandum in general meeting. According to section 13 clause 10, such alteration shall have effect after it has been registered with the registrar. Firstly, I will discuss with the alteration of the name clause. As per section 13 clause 7, a company may change its name by passing the special resolution and alter complying with the procedure specified in section 13 of the Act. But such name shall not identical with the other name of the company that is already in existence, or that must not resemble nearly to the name of the company that is existing company. And the second one is, it must not constitute an offence under any of the law. Third one is undesirable in the opinion of the central government. Any change in the name of the company shall not have any effect except with the approval of the central government in writing. Any change in the name of the company made under register shall enter the new name in the register of the company in the place of old name, and or only the registration of the new name registered by a company may be allowed if in the opinion of the central government that name is identical with or resembles with the name of the existing company, and it may direct the company to change its name within a period of 3 months from the issue of such certificate, from the issue of such direction after adopting the ordinary resolution. If a proprietor of the registered trademark applies to the central government that the name is identical with the or closely resembles with the registered trademark within 3 years of the incorporation of the company, it may be directed to change its name within 6 months. And where a company changes its name or obtains a new name as per section 16 clause 1, it shall be within a period of 5 days from the date of such name. Give such notice of the changing name to the registrar along with the order of the central government who made its necessary changes, who shall make the necessary changes, certificate of the incorporation of the company. Any change in the name will not affect the rights and obligations of the company. Talk about the penalty. If a company makes default in complying with the direction of the company, shall be punished with fine up to rupees 1,000 per day during the default continues, and every officer who in the default shall be punished with the fine that may not be less than 5,000 rupees and which may extend to rupees 1 lakh. And this was all about the alteration in the name clause. If we talk about the alteration of the registered office clause, there may be change in the registration office of the company. If the registered office is within the state from with the jurisdiction of one registered office to the jurisdiction of the another registered office, then also it can be changed from one state to another state. Change of the registered office existing the local limits of same state, town or village can be done by passing the special resolution by the company. Notice of such changing must be given to the registrar within 15 days of the changing in the registration office of the company. And change of registration office from jurisdiction of one registrar to the another registrar, it requires in the certain conditions. Number one, passing the special resolution by the company, and second one, in the confirmation by the regional directors on application made on behalf of the company in the prescribed manner. If we talk about the change of the registered office from one state to another state, it requires the passing of the special resolution by the company also. And approval of the central government on the application made on in the prescribed manner shall also be made. Next one is alteration of the object clause. As per section 13, alteration of the object clause of a company where the company has not raised money through the prospectus can be done by passing the special resolution and filing a copy of the resolution with the registrar of the company within 30 days in accordance with the provisions and manner prescribed by the Company Act. The detail in respect of the special resolution shall be published in the newspaper, which is in the circulation at the place where the registered office of the company is situated. And the next one is alteration the liability clause of the company. The liability of the members cannot be made unlimited without any consent of the members in writing. By changing the memorandum, an article of the member cannot be compelled by buying the additional shares of the company. A club or the association can raise the periodical subscriptions by altering the memorandum or the article without the consent of the members in writing. Further, the liability of the directors, members, and managing directors can be made unlimited with their consent, provided the article so provide. Further, the unlimited liability of the shareholders can be made limited by passing the special resolution, obtaining the approval of the company law tribunal. So, an unlimited company registered itself as the limited company. However, it will not affect any of the debts, liability, or the obligations already incurred, or the contracts made before such registration. And the next one is alteration the capital clause. A company can increase, reduce, or alter the capital of the company of its share capital. Altering the capital may bring any of the alteration of the capital clause may be in any of the following ways. That means alteration of the share capital, deduction of the share capital, and variation of the rights of the shareholders. The certain ways in the alteration of the capital clause can be made. If we talk about the share capital of the company can be altered if it is authorized by the article in the following ways: by passing the ordinary resolution and increase the authorized share capital by such amount if it is expedient, and such division of the shares into the shares of the lower denomination, and consolidation of the shares into the shares of higher denomination, and conversion of the fully paid up shares into the stock and reconversion of the stock into the shares, and cancelling the issued shares and issue of the new shares. If we talk about the reduction of the share capital, it can be done in the certain ways. That is, reduction of the liability of the shareholders in respect of the shares held by them. Second one, by paying off any of the paid up share capital with which it is in excess of its requirement, and conceiving any next one is cancelling any paid up share capital which is lost, and reduction of the share capital can be made by passing the special resolution and after the confirmation made by the National Company Law Tribunal. And the next one is variation of the rights of the shareholders, where the share capital of the company is divided into the different classes. The rights attached to the shareholders of any class may be varied with the consent of the shareholders in writing, by passing the special resolution. The 3/4 of such class of the shareholders shall also be obtained in case it affects the rights of any of the other class of the shareholders. The consent of 3/4 of such other class of the shareholders shall also be obtained. And if you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.